Hello and welcome to Newscentre. I'm Parikshit Luthra. Delhi's former Deputy Chief Minister Manish Sisodia, who has been in jail for 17 months in connection with the liquor policy case, has finally been granted bail. His appeals were dismissed several times in the last 1.5-year period. He was first arrested by the CBI on the 26th of February and then by the Enforcement Directorate on the 9th of March last year. While granting bail, the Supreme Court bench noted that Sisodia has been deprived of the right to speedy trial and there is not even a remotest possibility of the trial being completed in the near future. Joining us now to take this forward are lawyers Desh, Ratan, Nigam and Kapil, Madan as well. Desh, Ratan, Nigam, let me begin by asking you, is this now going to be a setback for the prosecution, considering that the Supreme Court observed that both ED and the CBI are contradicting each other? It's wrong to keep demanding incarceration of an accused on the pretext that the trial is going to begin when the trial has no remote possibility of beginning anytime soon.
Parikshit, let me tell you, I don't think this is a setback for the prosecution. Reason being, the only ground for opposition was that the person is influential, he may tamper with the evidence or influence the witnesses. Those two grounds they have said since all the documents are already with the agency, and so far as influencing witness is concerned, they have imposed a stringent condition that he will not make any attempt towards that end. However, now if you look at the bail under PMLA is different from bail under the ordinary criminal procedure. In the PMLA, there are twin conditions where it is clearly said that there has to be a prima facie finding from the court that the accused person is not guilty of such an offence. It's a prima facie finding has to be there. Second, that he is not likely to commit any offence while on bail, while granting him bail. So these are twin conditions, and there is no authoritative pronouncement on these two conditions by the Supreme Court. Probably they have gone under 142, which are the inherent powers of the Supreme Court, and that they can do. But it is expected when PMLA is involved, there has to be an authoritative pronouncement on these twin conditions. However, it has not been so. Supreme Court in its wisdom has thought that since the speedy trial is nowhere near completion, not has started also, so therefore it will take a lot of time. And they have imposed very stringent conditions for his bail, saying that he has to report twice on Mondays and Thursdays to the investigating officer, which is rare in the case of politicians involved. Therefore, serious issue is there certainly. So far,
same time, Desh, Ratan, Nigam, they've not. They've refused to restrain the Deputy Chief Minister Manish Sisodia from visiting the Delhi Chief Minister's office or the Delhi Secretariat. So that is a plea that they did not agree to. Kapil, Madan, if I can come to you, do you expect this order in this case to help Arvind Kejriwal as well?
So, Parikshit, I completely, agree with you to an extent that, this order will have an implication on Mr. Arvind Kejriwal's case also, because we should not forget that Arvind Kejriwal has been granted bail by the trial court itself in the ED case, which is, under challenge by ED. And if you look at the observation made by the Honorable Supreme Court in this case, the court has clarified that the trial courts are usually reluctant and they try to play safe in the bail matters, and they forget that bail is the rule and jail is the exception. And while, recording this, the Honorable Supreme Court has granted bail to Manish Sisodia. So insofar as this case is concerned, there are identical allegations against Mr. Sisodia and identical allegation against Mr. Arvind Kejriwal. In terms of their position in the society, both of them are politicians and they have roots in the society. One is the CM and one is the deputy CM. So if you also look at it from the aspect of parity, then Arvind Kejriwal will also have additional ground to seek bail. That is the ground of parity.
Right. Desh, Ratan, Nigam, if I can return to you, the court also noted that hundreds of witnesses have been examined in this case already. All the documentary evidence has already been seized by the CBI, the Enforcement Directorate. There is nothing really new to seize or question the accused about. So why should there be a delay in beginning trial? Because this is something that the Supreme Court took note of, that continued incarceration with the hope that the trial will begin, and accusing the accused for delaying the trial is a violation of the fundamental right of someone like Manish Sisodia. So how would you respond to that? Why do you think the CBI, the Enforcement Directorate, are not able to begin trial?
Well, the reason being the trial beginning is not in the hands of prosecuting agency. It is in the hands of the courts. Once a charge sheet is filed, then the courts take over. And in fact, if there is a delay in charge sheet, certainly then the bail comes into the question. Here, the issue was entirely of tampering with the evidence and influencing the witnesses. And Supreme Court certainly knew about the fact that there are thousands of documents and hundreds of witnesses, and therefore there is no likelihood of early, completion of the trial. I think it was on these two findings, that huge amount of sets of documents and the hundreds of witnesses. So there is no likelihood of, trial being completed in near time. Therefore, the Supreme Court decided to grant bail. It was only on the delay of trial. So far as the issue of influencing or tampering with the evidence and witnesses is concerned, I think they have imposed stringent conditions. And most of the documents, it is said that it is already with the courts, and therefore they cannot be tampered. One can agree, but a person, it is a simple principle. A person who is accused or is facing an inquiry, he is generally suspended if it is a labor or service law, so that he is not able to attend his office and does not, have that power to influence witnesses. That is a possibility where the prosecuting agencies and the police have to be very careful. So because he's a powerful person, influential person, he might, influence the witnesses. That is where the police have to be very careful. And therefore, the Supreme Court has put a stringent condition that he will not make any attempt towards influencing the witnesses.
At the same time, the Supreme Court also noted that the accused, Manish Sisodia, has deep roots in society. He's not a flight risk. Let me go across to Kapil Madan at this stage. Kapil Madan, what do you think the Aam Aadmi Party's lawyers' strategy is going to be now onwards, considering that the trial is going to take time? It's a complicated case running into hundreds and hundreds of pages, 400-odd witnesses. What do you think their strategy would be now?
So, Parikshit, in any criminal case, what happens is, usually what happens is that the first and the foremost, strategy is to preserve, the bail of the concerned accused, because there is a reason behind that. Because there are several judgments, and so it's a practical situation also. A person who is behind bars is not in a better position to defend himself, but if a person comes out, he's in a better position to defend himself. He can have endless meeting with the lawyers. He can have endless review, of the documents, which is a limitation. If the person is in the judicial or a police custody, he can't do, all these things. So my, understanding is that they will now scrutinize, every relied upon document filed by CBI and the ED both, and every unrelied document filed by the CBI and the ED. And I think they will be very closely scrutinizing the statements made by the prover, because you may recall, in this case, in the excise scam, it is the approvers who have made incriminating statements against these accused persons, and their strategy should be to have a very thorough, detailed cross-examination of this approver to show that he was either tutored or he was either promised any kind of reward or any kind of promise on the basis of which that statement was procured. You may also recall, in ED Arvind Kejriwal's bail order, it is on record that the ASG representing the ED has on record said that investigation is an art, and sometimes they give lollipop to the accused, to the approver or to a witness, to get hold of incriminating evidences. So if you see all these events in the backdrop, these statements of the approver against Mr. Arvind Kejriwal and Mr. Manish Sisodia is the plank on which ED's case is standing insofar as these two individuals are concerned. Once this plank is out, if they are able to impeach the credit worthiness of these approvers and the statement that they made during the course of investigation, I think this case will fall flat.
Right. now it'll be incumbent on the prosecution to make a strong case during arguments, and they would try and prosecute and seek the stringent punishment possible for the accused as per the criminal code. Mr. Desh, Ratan, Nigam, do you also believe that somewhere now there will be pressure on the prosecution to prove their case even more, because the bail in this case and the kind of observations that have been made by the Supreme Court, talking about the delay in completion of trials, talking about violation of fundamental rights of someone like Manish Sisodia, do you think all of that would put the prosecution in a spot? Will raise questions for them in the trial?
No, I don't think so that will happen, because judicial delay is a perpetual problem in our judicial system. And there are lakhs of, under trials whose trial is being delayed and they have not been given the same liberty. But the fact remains that we are not expecting the judgment in near time. It may take years before the trial is completed. And therefore, I don't think prosecution agencies will have to do their job. A lot of time, there are loopholes in their investigation. There are shoddy investigations. I hope it is not there in this case. They have made the complete chain of the evidences, because if there is a break in the chain, then the benefit of doubt goes. However, we must realize that it's a very different act. It was promulgated in India on account of the United Nations recommendations, resolutions. And for that year, a person is, for the purposes of granting bail, he is guilty till proven innocent. The jurisprudence has been changed, because such kind of offence affect the entire country and they weaken the country.
Okay.
Therefore, the issues are very serious in prosecution.
All right. We've run out of time, Mr. Nigam. Okay. Thank you so much, Mr. Desh, Ratan, Nigam. We've run out of time, and thanks to Kapil, Madan as well. We are going to take a break this time on Newscentre, but coming out, a double bonanza for India on day 13 of the Paris Olympics. Neeraj Chopra won silver in men's javelin, and the Indian hockey team won over Spain to get a bronze medal. A discussion with Olympian Adrian D'Souza and Adil Sumariwala, the president of the Athletics Federation of India, on the other side.